policy and we find something that's not meeting the needs of the district or has caused an issue for us, that is land the policy for review for front of this committee. So our first policy tonight is one of those. It is 13.3, screening evaluations for students with disabilities. There is only one minor change, and if you scroll all the way down, for me, it is page, I don't know why I don't have my page numbers. It's on page 4 at the top right there. We had language saying that when a parent requested an independent eval, that the district would make a decision about that eval within 10 days. So during the regular course of the school year, which is when most of these requests are occurring, that 10-day stipulation was easily met by the district. But during the summer and sometimes during other times when we're off, like during the holidays, that 10 days sometimes becomes problematic on our turnaround to get back and make a decision whether we're going to allow the independent eval or not. And then it forces our hands into due process, which we would like not to have happen. So in working with our new council, they came up with this language. It is not driven by an actual number. It is more of a reasonable time period. So we are proposing that it says without an unreasonable delay and within a reasonable period of time, we will respond with a request for that independent evaluation. And again, that is highlighted, and you can see the section we removed, and that is on page 4 of your PDF. Those are the only changes recommended at this time. In working with new council, we did kind of mark up some other pieces of this policy we may take a look at later, but for our purposes now, this is the only recommended change for this policy.
Does anyone have any questions or comments about this proposal?
Just one question. So if I came to you as a parent, school started and came to you next week, so what is an unreasonable delay or reasonable period of time? What would you tell the parent? That would be my question.
Mostly, so this policy has actually been in effect for a number of years for the district. I think, going off the top of my head, I think it's 2015. We've been able to meet the 10 days and then some without issue. It's basically just over summer, so then it would be depending upon vacations or anything. But we talked about it with council. They don't want to tie us down to an actual period of time, but we would probably give a 2-week period, something in that ballpark would be more than likely we'd be able to get that done. And then we still have the ability to say, if not, then we will inform you of when the district can. So we still have maximum flexibility there, but still are providing timely response to our parents.
Okay, thank you.
Absolutely.
Any other questions or comments?
Only because it's on page 2 under guidelines under parent guardian requests. It does say parents and guardians may request evaluation at any time. Parent guardian may request must be in writing. If the request is made orally to any professional employee or an administrator, that individual shall provide a copy of the permission to evaluate form to the parent. To the parents, guardians within 10 calendar days of the oral
Yes,
request.
so that's on a full-on evaluation.
Okay.
That's not an independent evaluation. We're only working with the independent evaluations for that piece.
Just curious as to why there's no consistency there. Does it matter? Am I
Correct. Like,
as a parent, I see one thing that's reasonable or / unreasonable, and a few paragraphs before it says 10
right.
days.
That's actually I can't change those numbers.
Okay.
The IE piece we were allowed to change in working with council. Those numbers you'll see in every policy in every district.
I have, I guess, 2 comments. First, I think saying without unreasonable delay and within a reasonable period of time is redundant. I think one or the other is probably sufficient. And it might be helpful, if nothing else, but so that the staff has information to communicate to parents, if we would say generally within X number of school days. And that way we're not giving ourselves a firm deadline, but generally within X number of days, that might enable the staff to give more clarity to students and faculty or students and parents who have questions.
So in this policy, that it's not going to be the staff communicating. The IE is going to be going to the director of special education. So it'll just be them communicating with the parent request. And as far as the language being somewhat redundant, I don't disagree. That was council's recommendation for the policy, and that's why it's in front of you tonight.
I have a question.
Dodson.
So, who monitors how timely these things are being done if there's not a firm requirement of days, of school
Well,
days?
so
I mean,
it-
how do you, how,
a lot of the things to Mr. Wagner's point over there is actually driven by specific days. And if we violate those days, we go to due process or things like that. Those are where those days will be a problem for the district. This situation here, the judge is going to look at the number of days that we took to complete this process. And if it's an abnormal amount of days and we're accused of stalling, obviously that wouldn't be something that would look good for the district if we got to that stage. So there's not it's more of the right thing to do, and it's also how things look if you were to go to litigation. Does that make sense? Like you wouldn't want to have a lot, you wouldn't want to have a lot of, you wouldn't want to have a lot of days in there. But there are times where, again, over the summer especially, you don't receive a lot of requests for independent evaluations. And I think it might also help to know that we don't receive a ton of requests for independent evaluations.
no, I understand the lag time when
Sure.
we have vacations.
Yep.
Just how, yeah, just to, just to make sure that it doesn't get lost, and so when,
When,
We
if
don't get
we're at a
that
point where
evidence.
it's an independent evaluation, it will not get lost. It's certainly something that's on the top priority for the director of special ed. And as I shared earlier, working with council, there is a whole other page or two of potential recommendations they like to make that pertain to IEs or independent evaluations, because they can be an area that can be very costly for districts. So I probably will be bringing back some at least comments or questions, or maybe even for discussion, because the IE process, if you're not familiar with, you're basically paying for an independent evaluation. And a lot of times those evaluations, when they're being paid for, come back a certain way. So it's something that districts need to be careful with.
so, and if this isn't, what I'm gonna ask doesn't pertain to this, that's fine.
Sure.
So just in general, and I know this was a long time ago and our departments have changed a lot. I had a child that was evaluated for a certain program. And I thought it would be like other schools we have been at, like, 2, 3 weeks. Like, it was almost 3 months.
Yeah.
And every time I would call, it was like, oh, we're working on it. We're
It's
working on it
60 calendar days.
for general, just for general evaluations. Okay,
Mhm.
thank you.
And we do have a very large school psych department, so we are pretty quick with that. We try not to take the whole window.
And I know we do good inspections periodically, and I think one time there were some things that, some papers had to be
Sure.
cleaned up, if you will, or found, or I don't remember the details of it during inspections. Okay, thanks.
Sorry to bring this back up. What was the answer to Mr. Donato's question? What was the answer to Mr. Donato's question? I'm sorry, I was.
His question was just like, will we be able to share an approximate time with,
Yeah.
with the parent involved? And yes, we would share an approximate time with the parent involved. We do, it's not a regular evaluation process, so it would be it'd be a family we're already working closely with and have had regular meetings with if we got to an independent evaluation. So there would be an approximation of when that time we would complete that time. And again, knowing that this has been in effect since 2015 has not been an issue for the district yet, but we did have something over the summer where it certainly moved some people along where they were on vacations and things that
Mhm.
council thought that this would be one of those areas to address immediately before we look at it as a larger policy.
I guess I would make 2 suggestions then. First, I don't like redundancy, so I would say it should say within a reasonable period of time. That would be suggestion number 1. Number 2, if we don't feel comfortable putting a time frame in the policy, I would suggest, hopefully with the support of the committee, that the administration develop internal procedures that would make clear that the expectation is that generally we get back to people within 10 days.
But
Is that,
I mean,
Right.
it's something that just the director of special ed would be responsible for. So we could just
Right.
tell the director of special ed that's how we would be.
right, and okay, if
yep.
that's something everyone's comfortable with, I think we can
Yeah, and I would say if there's some kind of extenuating circumstance, you're having a conversation with
Yeah.
that parent or guardian on the front end, not on day 10.
So, we're going to be hiring, we haven't hired anybody yet, a new director of special ed. So is that gonna be somewhere in his or her? These are the list of your duties?
These policies are all,
Speaking?
yeah, these policies are all something they're very familiar with.
Talking about just telling, you need to do this within.
Oh,
10
yeah,
days.
yeah,
Is there
we
gonna
would
be some
certainly, well,
rules
there,
or-
You just add it to the handbook.
yeah, there's a number of special ed policies that they're very responsible for, and they're part with our audit, even from our state person that audits, so all these pieces would be together, they would certainly
Right,
know.
I understand that. I'm asking because it was a verbal, requirement that would be told to the director of special ed now.
Yep.
Our former one's not here anymore, but,
So on the
is there
onboarding,
like a SOP or?
on the onboarding process, we could put that in there, and there's guidelines for how they, like, and that
guidelines
is one of the
SOP?
things, as I referenced a couple times, there's the IE process that actually might be more identified in policy moving forward as we work with council, and some of those components will be captured in there as well. So there might be some redundancy in the AR at some point that will change, but for a
If
starting
we've got
point,
policy and then we have to
for a
help
starting point,
implement
this
those
does
policies.
what we need for the district at this point in time.
Any other questions or comments
Yeah.
about 113.3?
I'm just gonna go on record really quickly. I mean, listen, at the risk of splitting hairs and, does this really matter in the grand scheme of things? You could probably argue either way. I will just go on record and say that a few things. Number one, I've been through this personally, right? And I've actually waited for more than 10 days at times for responses. So, and I can tell you that there is some lack of communication throughout the district, depending on schools and different departments. And so to me, this is a good way to give somebody an out, which I'm not okay with, especially when we're looking to hire someone into a position. So if I go into a position, if I'm interviewing for a position, the first thing that I see is, yeah, you don't have a time frame for which you need to get back to somebody about, I'm gonna be like, great. I'm not gonna be held accountable. That's my first thought, right? And this policy was just changed now, right? So I guess for me, this is just something to me that almost gives somebody an out. I just feel like it gives some absolution to being efficient and quick in response to something that to some parents is very, very important. So I guess I'll just go on record. If this is the will of the board, if this is the policy change, I'm fine with it. I just, I don't know. I think when we start to use arbitrary timeframes, and we don't actually put something down that actually is a specific number, to me, it just, I don't know. It throws ambiguity into a situation that does not need ambiguity. So
I just want to follow too. This is only for independent evaluations. It has
Yeah.
nothing to do with communication or anything else. This is
Understood.
it's a legal situation
I
is
get it.
what we're trying to address.
but it is communication and it is independent. It's fine. It doesn't matter what it is to me. It's still,
So, Mr. Wagner, I'm sorry, are you saying that you are opposed to the revision and you prefer to leave policy the way it is?
the first thing I said was at the risk of splitting hairs, if this is the will of the board and what the policy is, what needs to happen with the policy, I'm fine with it. I'm just going on record saying that I just, to me, I don't know. I look at things like this and I think to myself, like, oh, we're giving absolution somewhere where what I don't know why we need to, right? If you're a professional, like I've written emails to Dr. Musser before, I've gotten an email within 3 hours. Why isn't, you know what I mean? Like, you know what I'm saying? Or Dr. Ginger, or Mr. Bobrisky. So to me, why are we going to look at other positions in the district and go, just make sure it's reasonable? To me, this is stupid to me. So it doesn't matter. Again, I'm splitting hairs.
And
Probably.
one thing just with the IE like there's a lot of people that the special ed director will work with in deciding with the IE and who they're going to use as the IE. So we're also waiting on other people's timelines too. We don't want the district to be hampered by the timeline when they're operating in good faith.
Dr. Musser, how many requests on average do we get because if I'm reading this correct, so I have my child tested for a learning disability and the district tests the child and they say no. And I feel like my child does have a learning disability, I could request this then and
It's certainly not a regular occurrence.
yeah, I mean, because
it's-
it's tied in there, everything above that, there are guidelines that we have to,
Correct.
for the regular, when you think, you want your child, I want my child tested, well, that begins.
Right. That begins all the clocks and times that are, to Mr. Wagner's point, already established. In
Yeah,
code.
All right, in the interest of moving through the agenda, I'm going to make a suggestion here that I think incorporates what we're doing. Within a reasonable period of time, comma, and generally within 10 school days, comma. That doesn't firmly bind us to 10 days, but it clearly sets the expectation of what the time frame would be. Is that something that would be workable for the board and for the administration? Within a reasonable period of time, comma, and generally within 10 school days, comma, of receipt of a request. It doesn't firmly bind us to 10 days, but it does set what the board's general expectation is.
My only comment is I could move forward with this as it stands with the understanding that there's communication around responding appropriately in a time frame that as soon as possible. And that if there were unreasonable delays or it was not an appropriate time frame, that would be addressed internally, case by case. So I have no problem moving forward with.
Sound a little clear about the generally acceptable 10 days. I would be fine with that. It captures both the unreasonable and the reasonable. Yeah, I think we're splitting hairs here, but I think the 10 days held us to a standard that was unrealistic, and that's what we need to make sure we don't continue.
Yeah, I'm sorry, as a parent that has
Absolutely.
had to, as a parent who hates it when I don't get a reasonable, a response within a reasonable time frame. This says within 10 school days, so if I made a request 2 days before the end of school, I still have 8 days into, say, school starts in September, then I still have 8 days within September for an answer, recognizing that all the teachers don't work, the director does, but all the teachers are not working during that time.
We would still respond because that's going to go outside of an unreasonable time for the.
It should say 10 business
for the
days,
hearing officer,
not
yeah.
10 school
10
days.
working
Yeah.
I know, because
Well, it says school day, so I mean, it's the same thing. We're
No, your
working in
point
a
is well
school
taken.
environment, you know.
And the whole reason we're changing this is because of something that happened over the summer.
that's exactly it. There's a reason that we're even talking
Yeah.
about this. Let's get to the bottom of that and then figure.
Yeah.
It's a good-
Well, the only reason we're changing this is council told us to change it. So that's the reason. When it comes to legal liability situations, mostly.
So I just want assurances that there's going to be accountability. I understand policies, but we also have SOPs, procedures, et cetera, to make sure things are implemented guidelines, and that whoever the new director is fully aware of that. And also I forget what the lady's current title is, who's filling in, that she's also aware that the department is still responsible to act quickly, even though there's kind of some fudgeability in this.
All right.
Can we agree that maybe just leaving the language as it is and moving forward with this policy might be okay? And then at the end of the day, if for some reason there's challenges or problems with this time frame and it's not being enforced, we can always revisit the policy. This is not, a once and done situation. I guess my sense is council reviewed it. Could the language be tweaked a little to your point, Grant? Maybe, but does it say the same thing? I think we're splitting hairs. I'd like to move past it, but that's just where I'm at.
I agree, but I would like to either pick without unreasonable or within unreasonable. It's silly to list both of them. So I'm fine with revisiting. I would like to say within a reasonable period of time. Okay. All right. With that change, is everyone comfortable moving this directly to second reading? Because despite the fact that we've talked about it for 25 minutes, it's still de minimis.
Well, I have to say, if you have a kid and you're waiting for that evaluation,
Absolutely.
it matters.
No,
I mean it.
Well said, Linda.
Yeah.
Yeah,
I think
It
that's where,
drives you crazy as a parent.
that's where we have to trust that they're going to get it to you as fast as possible. And if for some reason that's not happening, that's an accountability issue on the inside. But we put ourselves at risk legally when we put in a time frame that's an unrealistic expectation. And when that's not met with things out of our control, we're still held to our policy. So I understand where legal's coming from.
And this
I get
part of
it.
the
I just
policy
wanna-
isn't an evaluation. It's so you can go outside to get an evaluation. The evaluation's already been done by the district and you don't agree to it. It's this,
I have to say, I do actually understand all of that. I just want to make sure that there's a procedure as this has changed, that the powers that be are aware that they're still going to be accountable for a quick time. If I'm a teacher, I mean, a parent, and it's like, oh, we're getting to it. We'll be back to you. And, it drives me insane. That's all. Whatever everybody else. And I agree with, we need to follow our legal solicitors advice as well.
okay. All right, we'll go ahead and move that to second reading. 115, career and technical education, Dr. Dandridge.
And just before we start that, I wanted to let you know Mr. Maurer has joined and is online, so he's participating. The 115 Career and Technology Education is up for review. It's been about 7 years since it's been looked at. We're really not looking at any changes here to the language. Cleaned up some formatting and we added a definition section. That definition comes out of school code. So that's been listed. There's now split into a purpose authority. The section in orange that's under guidelines was there previously. It was not under the guidelines section. I think it was up under authority. So all this is just cleaning up some formatting, adding a definition piece, and then looking to move it forward unless you have any changes.
Thank you, Dr. Dandridge. Any comments or questions? Seeing none, any objection to moving it directly to second reading? All right, 116, Mr. Cregan.
All right, can you hear me? Okay. The 116 is up for review. It last was revised in 2015. And the changes, looking at several school districts that similar size, locations, et cetera. Most of them, 6 of the 7 have the exact policy from VSBA. 1 didn't have the policy at all, so that's what we went off of. Really, the changes are to the designee titles, as in 2015, we had a director of student services, and we currently do not. So when you look, and I missed one, actually, excusal from school in the second paragraph, the tutor's qualifications must be approved by, should scratch out director of student services and add assistant superintendent there, as I missed that one, I apologize. Down below again, the director of human resources was changed to student services offices as they manage the homebound instruction, tutoring, et cetera, no longer the director of human resources. And then moving down forward, the same thing, removing director of student services, adding assistant superintendent. So pretty cut and dry compared to similar to what everyone is following.
All right, thank you, Mr. Cregan. Any comments or questions? All right, seeing none, any objection to moving 116 to second reading? All right, we'll go ahead and to second reading. 216.1, Dr. Musser.
Thank you. So both of these next policies are results of compliance and PSBA updates. So they're quite lengthy. I know I really like to provide the highlighted cross out for the board to see our current policy compared to the new policy, but considering the drastic change in policy in both of these, I was unable to do that. As far as the supplemental discipline records, it really references a lot of responsibilities that the probation officer has and the school district's responsibility in working with the probation officer and sharing some of the discipline pieces that are able to be shared to maintain a safe environment, but we're also still concerned with protecting students and giving them a fresh start in the districts that they're in from a discipline standpoint. So you'll see a combination of those steps here and where and how we can handle certain discipline requirements. A lot of the steps that are identified in this policy here, we're already completing in our enrollment policy. This just adds some additional responsibility, as I said, to the probation officer and also to the principal to make sure that some of those communications are being had and that everyone's in the know about discipline records that students have that rise to a level that they need to be communicated. It's not, it's still sharing, it's sharing information that is needed to be shared without some of the discipline, because we were all kids, we all make mistakes. It's not sharing some of those pieces. Kids are still getting a fresh start, but it is sharing some of those higher level offenses, as you can see in the policy, that may require additional either work or threat assessment or additional services for that student to be successful in the educational environment.
Thanks, Dr. Macho. Any questions or comments about 216-1? All right, since this is a substantial rewrite, can I suggest that we move it to first reading? Any objection? All right, 216-1 to first reading. 251 homeless students, Dr. Macho.
So 251, similar. This is all as a result of the Act 1 change. And we're probably going to be required to have this policy in place by the time our next homeless audit is in place. So it outlines a lot more of what the district is required to do. It kind of, and I had a little conversation with Mr. Keener about this, it kind of moves a little bit from ARs, and by putting a lot of the actual stuff in the policy, the requirements for the policy. But outside of that, it's a lot of the same stuff that we were doing and responsibilities that the district had to make sure that students, regardless of their home situation, have a chance to be successful and earn a diploma.
Thank you, Dr. Macho. Any comments or questions about 251?
I just have a question. Under the check where it checks the homeless child or youth liaison or student services coordinator, I'm assuming that individual would have to be 18 years or older to qualify for that delegation in that line item?
So that's actually saying the board's going to, we used to have that be the director of student services. We actually have a homeschool liaison, an employee. We're required to have one appointed for that. That's who is going to be in charge of that. That's why that's checked. It's who the board designates to make sure that those things are being handled.
So the
It's-
board
it's
could
going to- it's going to
designate
be our
the
coordinator.
child, the board could designate the child to be in
The
charge of
board's
that?
designating that our student services coordinator, who handles all our homeless, he's our homeless liaison, makes sure that the district's in compliance with all those pieces.
I'm just reading this
you-
wrong, I guess.
You
I'm
are,
misunderstanding.
it's the homeless child or youth liaison, the child or youth liaison are
That's the
connected.
title.
I
You
got
see, where I'm
Yep.
reading this,
Yeah,
I'm
correct.
saying that the way I interpreted it when I
Correct.
first read it was that you have three options.
Yes.
So, okay, I
Pri-
got you.
Prior to this, we would have had when we had the director of student services position, that would have been that position. In a lot of other school districts, you'll see it be the assistant superintendent.
I see where you're going with
Yeah.
it. It's good. I'm okay with it.
Any additional questions or comments? All right, any objection to moving 251 to first reading? All right. And finally, pardon me, 616 payment of bills, Dr. Macho.
So some real quick housekeeping here, as you saw a little bit with Mr. Cregan's policy as well. We just took out the treasurer under 4 there, where it says all checks approved by the board shall be signed by the president, board secretary, and treasurer. We do not require the treasurer to sign. And then also you'll see the removal under guidelines, the removal of the treasurer to have any grave signature stamp, because we don't have the treasurer sign. There would be no reason for them to have a stamp. So not very exciting. I'm sorry to conclude on something like this, but here it is.
Any questions or comments about 616? Any objection to moving 616 directly to second reading? All right, 616 to second reading. The last agenda item we have is just, and I'm sorry, Mr. Mauer, any questions or comments from you? I'm not trying to ignore you.
None.
Mr. Mauer?
No questions.
Mr. Mallow, we appear to be having some audio difficulties. If you have any objections or comments, if you could throw them in the chat, and then we'll wait until we establish a connection. All right, thank you, Mr. Mallow. All right, and then we have one discussion item. This is discussion on social media accounts, and by way of background, I think this is just a general discussion about the degree to which you should consider the district's official social media account to be full public forums or Thirsty?
Yep, so I received some questions and did a little research, connected with Mr. Walker, our solicitor, just to get some from legal perspective. Currently, the district social media accounts have been operating as a limited public forum, meaning individuals can post just under certain criteria. So, Mr. Keener, to your point, you can have a full, a limited, or the third option is a closed. Closed meaning no posts. It's just one way. It's us pushing information out. The district has operated historically from a limited standpoint because we think it's important. It's a means for people to be able to ask questions or give feedback back to the district. The challenge at times comes in terms of maybe what people post and how far are those posts going in terms of whether they're accusatory of individuals, derogatory, et cetera. But as a district under a limited public forum, we have the ability to establish very clear protocols for individuals if they choose to post, and we need to be able to communicate those and then adhere to them. And then if someone is not adhering to it from a limited public forum, their post can be removed. So was able to get all that clarified and wanted to bring it here just because within our policy, it talks about our Director of Communications and Community Relations has the ability to make that designation as long as we are following the criteria established. And given that we are currently in the interview process for a Director of Curriculum and Community Relations, wanted to bring it here just for some additional discussion. Any other thoughts? I do think it is wise to be able to get feedback and keep it at a limited public forum after consulting with Mr. Walker. But I would like to make sure that when we bring someone on that we refine and look at those expectations and make sure we update them if needed and then clearly communicate them and make sure it's being enforced with all district accounts. But wanted to bring it here to see if there was any questions or concerns or any additional information that you may from me on that topic.
I have a few comments and concerns. First, let's decipher between the difference between a post and a comment. The post is actually when someone from the district is going to actually post an event or something like that with possibly limited information, not on purpose, but just to express what's going on. The issue that's been arising is the comments that are freely able to put on there that are not accurate. And you said you can delete them, but when it happens on the summer, those comments go like wildfire from Friday till Monday. And I think there's a problem with that.
I just have a general comment. I would support Mr. Bard to some degree in the concern around that. So I would suggest we either continue with a limited option, obviously, where they can be removed if they're inappropriate, because unfortunately, a small group of people, can taint the waters for everyone when they put inappropriate things on there that are inaccurate. I would also probably consider even supporting some kind of a more stringent policy where the information flows one way, especially if we're having issues there, which I don't know if we are, but if we are, maybe it has to go to one way. And unfortunately, that will be uncomfortable for people that truly have a legitimate post or comment to put there. But there's also some people that can't be trusted to post appropriately.
The problem is the current way, which is limited. If someone's not policing it for those 3 days, it's a problem. And I don't think there's a one way that will allow comments. Is it correct?
It could be where the district would post only and then there would be no comments allowed. That would be the closed forum. But what we cannot do is kind of go post by post to determine the type of forum. Once you establish it for the platform, that's how it is. And
So what I would recommend is the person that posts can be messaged, direct messaged. So whoever has a question, if they want the accurate response, it should go to the person who made the post, rather than a wildfire event on the post. Because if you have a 3-day, 4-day weekend, it's not like we have someone sitting on there, a moderator, watching to delete stuff within 2 hours. I mean, we just experienced something recently where there was false information and it went crazy, and it potentially is damaging to other people.
I like the idea of a DM. I think that makes a lot of sense, right? I mean,
What was that, Mr. Wagner?
is the microphone not close enough to my mouth? I can eat it if you'd like me to.
Wonderful,
so-
thank you.
Oh. All right, so I don't think it's a bad idea actually to have a direct message, have a DM. I think it makes sense. I guess my question is, what information would we be sharing? What is the actual like what are the things that we are using our social media platform for, right? It's to send out messages, it's to just to share general information so that the community, the student body, the parents, the teachers, the guardians can see it, correct? It's not to start a debate. It's not to poke anything in the wrong way. It's just to provide information. And if there's comment or thought around that, why not come back directly to address it? Yeah, I think it's a great, I because then you still have a two-way street, but it's a controlled street, right? Can't have everybody just saying whatever they want anytime to anybody.
This particular situation that I can elaborate on is they could have gotten all the information they wanted from the person who made the post. They chose not to go that direction because they wanted an answer immediately, and people chose to run with it. There was a phone number put on the post that if you want the real information, that person's available. Nobody's doing that in this particular situation. So I think the one way, setting up that the post is on there in good spirit, but if someone has a concern about it, they DM the originator of the post.
I could be okay with that.
Makes two of us.
Questions or Comments about whether the district social media account should be public forums, limited public forums, or closed forums.
My only other comment is I don't think we have the time to police that. And in this current climate, I think that just adds additional burden to the district to pay attention to that and put out fires that probably could be avoided.
So you support what I recommended.
So we're suggesting a closed forum, correct, Mr. Barrow?
What would you call that? Closed. But they still have access to the DM.
Absolutely. And perhaps the district could put something up, like a message box, or something. Maybe we have it already, like where they can.
I would have to work and with the individuals around the social media platforms to determine what is possible in that. See where we go. Any others?
All right. Additional comments, Mr. Mauer, any comments? Mr. Mauer, you're muted. Mr. Mauer,
No questions.
no, okay. All right, sounds like we have a consensus around the closed forum. Any additional
Hear you.
items other than?
The only piece I would just like to say, and I know I messaged them, but I just want to say publicly, thank you to Mr. Bard and Mr. Mauer who attended our kickoff with our staff yesterday. We gathered together in the Performing Arts Center, and it was a great way to welcome staff back and a great positive energy, and just thank you both for attending.
Enjoyed it very much.
Thank you, Mr. Pomersky. Is there a motion to adjourn to executive session for collective bargaining?
So moved.
Motion by Mr. Wagner. Is there a second? Second by Mr. Donato. All in favor? Meeting adjourned. And Mr. Mauer, we will be adjourning to executive session.